The SEC clarifying its position on crypto assets, interpreting digital commodities, digital collectibles, digital tools, and stablecoins not to be securities. SEC Chairman Paul Atkins joins us live from Washington this morning. This is a pivot of sorts. Help us understand, and we'll probably get into the weeds of it all in terms of just the mechanism for all of this, but how you landed on this decision and what it means.
Oh, well, thank you, Andrew. It's great to see you again, and this follows up on some of our prior conversations about this and other topics when you've been gracious enough to have me on your show. So thank you very much. But first of all, yes, yesterday was a real break with the past, a formal break. The Commission came out for the first time with an interpretative release that really sets a line between what are commodities in the digital asset space and what are securities. And the significance also about this particular release that we did is that the CFTC participated with us in it. And so they had some guidance that's included in that release along with our interpretation. So basically, as you said, and that tripped off your tongue very well, so it's very good, we are outlining 4 types of assets that are not securities, and those are digital commodities, digital tools, digital collectibles, and stable coins. And stable coins per the Genius Act that was enacted last year. So we're breaking with the past. We are now giving clarity from the SEC's perspective as to what are and are not securities.
Okay, so it's funny. As I was looking through the list, the one I wanted to actually focus on, oddly enough, was digital collectibles, because I could see how a digital collectible, perhaps more than the other 3, could be considered a security depending on how it's structured.
Well, that's true with anything. And so this is also what this interpretation lays out, is we're looking at there's an old case from 1946 before the Supreme Court. It was called SEC versus Howey, and it had to do about orange groves and that sort of thing. But today, obviously, with digital assets, those principles apply. But what we are focusing on is what makes an investment contract, which means what makes a security. And we're focusing on the promises and the representations that the people who are constructing it make to their purchasers, their investors. And so some of these collectibles, like a baseball card, an equivalent, a meme, one of these meme coins or things like that, NFTs, non-fungible tokens, those are something that somebody buys. It's an immutable purchase that someone has given, and the token is what's set aside and collected, and it's not something like another asset where people are trading it, and there's an ecosystem around that.
So what? Just to define it for the audience, what is a digital security then in your mind, which you would regulate?
Well, a digital security goes back to what is an investment contract, and that is a set of promises that the developer of that particular instrument has made to investors as to how it will be managed and what what rights they have to that particular in that particular investment contract, and how they expect to make money off of it. So it's more than just something that is sold as a thing to hold or collect. It's more than a tool, like a ticket or something like that, a secondary ticket for a box office or whatever. And
what happens if let me ask you this, just because this may be the future, or people talk about it being the future. You buy a digital ticket or a digital card that is a collectible, but also 10% of it gives you some kind of stake in the future of the business as well. Is now that a security all of a sudden?
Well, so you're talking about there are things that are somebody's putting money into an investment that is an ongoing enterprise where people are supporting that and managing it. So this a facts and circumstances case. What we have done is set out all sorts of examples in this particular interpretative release, and setting up a process and a framework by which people can have certainty. Their lawyers can give them an opinion. They can come in and talk to us about things if they are unclear. And unlike in the past, they won't then go home after they've talked to the SEC and find a subpoena on their doorstep or something like that.
Right.
So we're setting up a framework. This is just an interpretation, and so courts can deviate from that, of course, if they don't like our rationale. But what we're also going to follow up with here shortly is a proposed rule that will put a lot of this into effect and be much more specific, construct a series of exemptions and equivalent of a sandbox for people to do experimentation to see if they can develop a proof of concept and then go forward with what their product might be.